case 4:20-CV-00128-TWP-DML, file date 6/18 of 2020. Frederick D. Jones Jr. versus Life Springs Mental Health. Um, at Life Springs as defenders. The notice states notice, consent, and reference of Civil Rights Act up to magistrate judge. Notice of magistrate judge availability. A United States magistrate judge of the court is available to conduct the proceedings in this civil action and to order the entry of final judgment. The judgment may then be appealed directly by the United States Courts of Appeals like any other judgment of this court. A magistrate judge may exercise authority only if a party voluntarily consents. You may consent to have your case referred to a currently assigned magistrate judge, or you may withhold your consent without advised substance consequences. The name of any party withholding the consent will not be revealed to any judge who may otherwise be involved with the case. Consent to magistrate judge authority. If all parties consent to have currently assigned United States judge magistrate to conduct all proceedings in this court, including trial and entry of final judgment and all trial post proceedings, they should sign their names below. Should this case be reassigned to another judge, any attorney or other party may object within 30 days of reassignment. If no objection is filed, the consent will remain in effect. Notice of documents is eligible for filing only if executed by all parties. The parties can only express their consent to jurisdiction by magistrate judge in the case management plan. It is ordered. This case is referred to the current assigned United States magistrate judge to conduct all proceedings under the entry of final judgment in accordance with 28 U.S.C. 636C and assign the date of order. Any attorney or party of record may object within 30 days of such reassignment. If no objection is filed, the consent will remain in effect. I wrote, as stated in the order, you are available to conduct all proceedings in the Civil Rights Act as your clerk, as well as she is responsible for clergy of the case of actions, and you ask or order me to take action. Is the court aware that I am indigent and lacking transportation and under fire, as I can't afford an attorney? I don't know how you appeal a case without judgment, nor see why you need their consent to act according to law. You put my life in jeopardy, in harm's way. If I mail it, they will probably prolong the situation, or in person refuse or start something negligently as to catch me evenly. As mental health, they've done this before and committed perjury. Would they do this again? Is question for a suit of such. It is your jurisdiction and duty, having the consent, for me to say they have more rights than me, and you are a magistrate judge seeking to drop the order, and you fulfill the duties as victim rights. Rule 60 gives me the right to assert these rights, as I feel you're being biased I represent myself and play in the favor and the defense. Because even though what he says, that they have a right to appeal, what can you appeal if it's already a complaint and it's a formal complaint and it's legitimate? Then it has to be granted. It's illegal not to report a crime in this country or whatnot. Then he says that he don't have to file something that he knows is wrong because they don't consent to saying that they're wrong, which they are defense. Obviously, they will say they don't want to go to court, so you have to make them go to court to a law because they broke the law, like you're lock up criminals or whatnot. That doesn't make any sense. And he says this U.S. code, there's no statute that says something of some sort like that when it's illegal not to report a crime, and it's illegal not to act on a crime. When you know something like it, you can do something about it too, because then you allowed it to happen. Then you saying you will allow them, if I don't get them to sign it, they don't sign, you say you allow them to not be punished or whatnot because they won't sign. What type of shit does that? What type of sense does that make, or whatnot? And that's going to be on the rest of the cases. Case calls 4 20 cv-00137-SEB-DML, and also case 420 cv-0032-TWP-DML. It's like that on all these other cases too. I don't know how he would how is that accordingly, or not? That is bias or whatnot. When they would know that I can't afford an attorney and all that, and I had to do all that, and it's really their job to do such a matter to contact the defendant and whatnot against my alleged allegations. What I say, they don't have any consent when they ask the questions. Ask them the questions on what I complied against them as my allegations. Ask them to answer those. If they don't answer them correctly or good enough, then they automatically have to go into the jail. Or not to jail, but they have to be. You have to file the suit and grant the motion and the act, and they have to answer allegations, which they already answered them. So I won the suit already. Then you are prolonging to work in the favor. You're being biased.